Hey, welcome to the Friday show brought to you this week by Woodbine. We're only 2 weeks away from the Queen's Plate, August 21st. That's on a Sunday. We've got some stakes racing this weekend, including the Grade 3 Ontario Colleen Stakes on Saturday. $100,000 guaranteed pick 5 every Saturday and Sunday going forward. And that's a 20-cent minimum bet. Hey, I'm joined by a longtime legal analyst, horse owner, a standardbred horse owner, breeder, Andrew Cohen. We're here to talk a little bit about all of the legal challenges surrounding HISA. Andrew is currently with the Marshall Project. I know he was with CBS Radio for a lot of years doing legal analysis. Welcome to the Friday show, Andrew.
It's good to be here, and it's nice to be sponsored by Woodbine. I'm a Canadian after all, so there's some synergy going on here. I had some wonderful memories of Woodbine and the Mohawk deal that they have going on. I guess the Standardbred's now only at Mohawk, but Woodbine's a great place, and it's a great place to race and to win.
Yeah, and I think a lot of people who haven't been to Woodbine, I don't know if they appreciate what a world-class city Toronto is. That's one of the great things about going to Woodbine is you're just 20 minutes away from downtown Toronto, and it's a great city, it really is.
Yeah.
So I don't know where to begin here. My head is kind of spinning with lawsuits and injunctions and stays and briefs, how do you say that?
Amici briefs and amicus briefs. Yeah.
Friends of the court, I guess they are.
Friends of the court.
I'm just going to do a real quick outline of where things are with litigation. There have been 4 lawsuits filed against HISA that I know of. The first was in Texas, filed by the HBPA and a number of affiliates. The second one was filed in Kentucky. Those 2 were dismissed by federal judges and have been appealed. And the documents for the appeal have been rolling in on the Pacer account online. A third lawsuit was filed in Louisiana just before July 1st, trying to get HISA from going into effect. That failed originally, and then the same judge said on July 26th that HISA cannot impose regulations in Louisiana and West Virginia, the 2 states that filed that suit. But then the Court of Appeals has issued a stay of that injunction. Now, while that was all going on, a 4th lawsuit was filed, another one in Texas, this one filed by the owners of Lone Star Park and the owners of 2 tracks that say they were going to go into business. It weren't for HISA. In fact, they've been around since 2009 trying to get something going at Laredo Downs and a track in McAllen, Texas. But a lot of the suits have the same ring to them, that HISA is unconstitutional. The lawsuit in Louisiana said that the rules were adopted improperly against federal law. Andrew, what do you make of all this? Is part of the strategy by the opponents of HISA just to create chaos?
Well, I think that's part of it, and I think it's a fascinating dynamic because what you have, I think, is the partisanship angle that's being played in a story about a case and a law that really isn't a political thing. So you have 2 sets of lawsuits that you've described, Ray, and you've done a really good job of it. The Texas case and the Kentucky case are traditional challenges to the constitutionality of HISA. The folks in those cases have said Congress had no authority to enact HISA the way that it did. It's an unconstitutional infringement on state powers. It's an unconstitutional delegation of congressional authority to this private public entity called HISA. So those are direct challenges. 2 conservative judges, trial judges, both rejected those arguments. I think a Trump judge in Texas did so at the district court level. And I want to say a Bush 2 or Bush 1 judge in Kentucky. Both hard rock conservative judges said, no, HISA is constitutional. It's not perfect, but it is not beyond Congress's scope to be able to implement such a law and to direct the agency to run it. Those are going up the ladder. They're on appeal. I would imagine it's going to be months and months and months to get that resolved. And then, of course, you might even have appeals to the full circuits or even the U.S. Supreme Court. So that's on the long-term track. The opponents of HISA, Ray, lost a huge battle when those two district court judges refused to enjoin the law. That's what they were hoping for, right? They were hoping to come into court and to have a judge say, the law cannot go forward. It cannot be enforced until we resolve these legal issues. Everyone knows it's going to take years and years. So I think what the opponents of HISA did was say to themselves, we're in big trouble. We have two conservative judges who have said the law is okay. Those judges are going to get some respect from the conservative federal appeals court judges who are going to look at this case. We better figure out something else to do. And what they've decided to do, evidently, is to challenge the rules that Lisa Lazarus and her folks at HISA are trying to implement and adopt and work on with the horse racing community. If you're a member of that community, you've paid any attention at all, you know that there was this period where they were asking for input from the horsemen and horsewomen. They wanted to adopt these rules. Now, the Louisiana case that you're talking about, the new Texas case you're talking about, those go not to the constitutionality of the law, but to the actual nuts and bolts rules and regulations that HISA is trying to implement.
Yeah, I think the Texas case is kind of, I think it's the Texas case, the new one, is kind of a kitchen sink approach. It seems like they're throwing everything in there. Almost every amendment to the Constitution has been violated, and the promulgation of rules as well. That I know in the Louisiana case, there was some really what I would consider minor differences between what the statute says in terms of, for example, what is a covered person or what is a covered horse, as far as who has to register with HISA, and then what was actually in the regulations. There were a few words added to the regulations that were not in the statute. So those are things that it's kind of hard to believe that you're going to file a lawsuit over that, rather than just saying, hey, you need to change a few words here to make it align perfectly with what the statute says.
Yeah, I think that's fair. And I, the other thing that's interesting, the Louisiana rulings over the past couple of weeks have gotten a lot of attention. That fight that's going on there, the judge did enjoin the implementation of the law, at least in those two states, and to the people who had filed that lawsuit. And then there's a big fight about what exactly that means, right? Whether that's a national injunction. But what that judge also did in the ruling was to say, whatever problems I've found in HISA and its rules and regulations can be fixed by HISA in its rules and regulations, that there's still enough time if they want to cure whatever defects I've identified, go for it. There's nothing in my ruling that says you can't do that. And in my perspective, just from watching it from afar, because the standardbred industry, to its discredit, is not part of this yet, is that the HISA is trying to work with folks. They have made some concessions. They are tweaking the rules. They knew it wasn't going to be perfect. So I think that's an interesting invitation from that judge. And I think that HISA folks, the lawyers and the folks who are managing it, are probably smart enough to take up the judge on that offer. And I think that's where we're likely to see some action over the next couple of weeks.
The stay that was just ordered by the Court of Appeals in New Orleans against that Louisiana injunction means, at least for now, that HISA regulations can be enforced in every state, including West Virginia and Louisiana, which had gotten the original injunction. And also it makes rather moot the question of whether or not that judge's injunction applied to Jockeys Guild members riding in all states. That would have kind of created, I think, complete chaos if you have Jockeys Guild members riding to one set of rules, non-Jockeys Guild members riding to a different set of rules. I mean, it just would have been silly. As far as that stay is concerned, it's temporary, and it's not based on the merits. But can you explain how that panel ruled on this?
Right now, as we're talking, there's an administrative stay in place. And an administrative stay is basically a signal from the court. We see it often in the U.S. Supreme Court in capital cases that are moving, towards an execution, and there's an execution that's imminent. Sometimes you'll see an administrative stay. What that is the judge or justice is saying, we need a few days to figure out what we want to do. everybody just freeze for the next few days until we make a ruling on this issue of whether there should be an injunction or whether there should be a stay. So we're getting this at the end of a week. I would imagine by next week, early next week maybe, you're going to actually get a decision on the stay. Either that federal appeals court, I think it's the Fifth Circuit, right? Either they're going to issue a stay, which would be good news for HISA and bad news for the folks who are challenging it, or they're going to allow this Louisiana trial judge's ruling to proceed, at least for now. You bring up a great argument, I guess, in favor of a stay, right, Ray? Because even the judge's ruling, as limited as it was, has created this chaos. And I'm sure that HISA has gone into court. I know that HISA has gone into court and said, we can't have this half in, half out. We need you courts to presume the statute is lawful, which is what the law requires, and to allow us to continue to enforce it and implement it and tweak it and so forth while you're figuring out what these challenges are. So to me, it's a really desperate attempt by the folks who are the opponents of HISA to figure out a way to stop this thing after they lost those first early battles. And I don't know that it's going to really end. I mean, even if they're thwarted here, there's going to always be another judge that they perceive to be favorable to their cause. It's called judge shopping or forum shopping. We see it a lot in general legal stuff, trying to find somebody who's going to be sympathetic to the argument. And that's really one of the things that you and I wanted to talk about, which is, and I mentioned at the top, this is not a political situation, right? In my view, this is a pretty standard situation where you have a hodgepodge of state regulations that are confusing and chaotic and not being enforced in a way that makes sense. So you have the federal government to come in and say, we're going to make a national uniform rule or a series of rules, and we're going to get the states to abide by them, and we're going to bring some order to this chaotic industry. This is not the first time that's happened, and it's certainly not the first time the courts have recognized that Congress has the power to do that. And so that's the reality of the situation. The sort of optics of it are that you're trying to create this, I think, political perception that this is a states' rights issue and this is the big bad federal government coming in to oppress the liberties and the freedoms of the people who are, working in and around state racing commissions. I suppose there's an audience for that kind of argument among the federal judiciary, but I don't know that it's so extensive that it's going to generate a victory on appeal, even at the U.S. Supreme Court, which I think would be open to it as well.
Yeah, it's interesting that on the appeal of the original Texas lawsuit, there was a brief filed by three of the sponsors of the Horse Racing Integrity and Safety Act, Mitch McConnell and Andy Barr, the minority leader of the Senate, and a congressman from Lexington, and Paul Tonko, Democrat. The other two are Republicans from New York. And in the brief, McConnell lays out and Barr and Tonko lay out very well the state of racing before, talking about the indictments of the 24 plus people a couple of years ago, talking about the spike in fatalities at Santa Anita, and brought up an editorial in the Washington Post that said, should racing cease to, raise the question of should horse racing exist anymore in this country? I thought their brief was very powerful, actually.
Well, it's powerful for what it says. It's also, I think, as powerful for who's saying it, right? So, if the argument for the anti-HISA folks is we're going to try to find like a conservative stream of judges here who are going to be sympathetic, and we're going to win at the trial level by convincing a judge that this is some sort of federal overreach. And then we're going to go up the ladder and find a federal appeals court judges who find likewise and go up to the U.S. Supreme Court. If that's the idea, boy, these judges are going to read Mitch McConnell, right, saying, hey, folks, this law isn't perfect, but it was designed to fix a really serious problem that we all acknowledge. It had bipartisan support. It's necessary. It's limited I think that's going to be something that's going to gain traction as well. It certainly makes it more difficult for a judge who wants to see this issue in some sort of partisan way to do so. I think it makes it harder for that judge to do so, given what McConnell is saying about it, given the fact that it does have bipartisan support, especially from those kinds of people.
Right. The HBPA, the National HBPA, cited a group called the Liberty Justice Center is helping them in their legal challenges to HISA. What do you know about them?
Well, that I think is part of the political dynamic to these cases now. And I think you see it. You even saw it in the initial cases out of Texas and Kentucky, which are two cases that I read into pretty carefully around the time of those decisions. Mm-hmm. And there has always been an argument here made by opponents of HISA, not just the ones who have litigated, but the folks who are sort of on the sidelines, that we don't need the federal government, that ultimately this is sort of a states' rights thing, and that each state should be left alone to regulate horse racing to the best of its ability, and that the system as it's working now is not so broken that it requires some sort of dramatic fix, and that the attempt to fix it is some sort of nefarious plot to extend the reach of the federal government over states' rights, states' liberties, private rights, private liberties. There's obviously a place for that conversation in American law right now, in the world beyond horse racing, but I'm not sure it applies to something like this. And I think even McConnell and Andy Barr and those guys understand that, which is why they wrote their response the way that they did. I think they're trying to undermine the argument that this is an example of federal overreach, that it's more of a case of help needed, help offered. And, the really interesting part here, I think, is the effort that it's going to take, and it is taking, the HISA folks to reach to the community to try to convert people who are skeptics to this, and to have everyone be patient enough to see it unfold once it's up and running and fully up and running. And I think that's sort of a fascinating dynamic, right? As this long legal process unfolds, there's this scurrying around, right, to implement the health and safety stuff, then to get to the drug and medication stuff that's coming down the road. The Standardbred industry that I'm so involved with, we're watching everything really carefully, and appreciating the fact that it seems to be evolving, that there have been some concessions, like I said, made by HISA that horsemen basically demanded. I think as long as it continues in that vein, I think that it's going to be less and less possible for judges to justify a decision to overturn the law. So I think that's accounting for the desperation of the folks who are opposed to it.
This reminds me a little bit of the fight against the Affordable Care Act, or Obamacare. It went into existence while it was being challenged in multiple cases across the country, trying to stop it in its tracks. And it seemed like the more traction it got, the more popular it became. People who came to understand it. It seemed harder to dislodge, and I think they won just about every court ruling, with the exception of one. And I don't know how many years it's been now, at least 10 or 15 years. Obamacare is more popular than ever. Insurance costs are lower, or insurance, not people who are not insured at an all-time low, I think.
Yeah.
So I don't know if there's any similarities between the two in your mind, but it just seems like there was this just unending fight to overturn Obamacare.
Well, I think that some people worry about anything that's new, and so that's, I think, accounted for some hesitation or opposition to the law. I've talked to a lot of people in our corner of the industry, and people acknowledge it's hard to find somebody who says, "Hey, this system, the way it's working with the state racing commissions, is great. All the cheaters are apprehended. There's this great feeling of integrity in the sport. All of the people that we suspect of being cheaters have been questioned, and the guilty have been, it's just, nobody says that. And I think nobody says that because nobody believes it. So everyone, I think, on some basic level acknowledges that the status quo has to change.
Yeah.
And they just don't happen to know exactly how they want to change it, or they don't believe they ought to change it in the way that HISA purports to change it. And I don't know that you're ever going to convince folks like that to come over until they actually see the new regime in place and working. And that's a challenge for Lisa Lazarus and the folks at HISA. It's a challenge for everyone within thoroughbred racing and standardbred racing who support HISA to try to convince these other folks to give it a shot. And I do think it's significant how the courts respond to it. To me, I'm not so interested or worried as a HISA supporter of the Louisiana case that you mentioned, because like I said, HISA can just fix its rules. HISA can basically say, Judge, you're right. We're sorry. We meant to give an extra thing. We're going to give an extra 14 days notice or whatever the judge is demanding. Right. The big fish are those two cases out of Texas and Kentucky. Those go to the core of the stuff. Right. And, if you get if these federal appeals courts in these two circuits agree with their conservative colleagues that HISA is not perfect but is constitutional, you would think that there would be some reckoning for the folks who have brought these cases, and that they would come to a bargaining table and say, okay, we gave it a shot and we gave up. That didn't happen in the Affordable Care Act. There was still litigation going on a couple of years ago. There are some true believers who still want to fight that fight, and they'll always want to fight that fight. And I guess that holds true for HISA too.
Well, Andrew, thank you so much for helping a lot of us understand some of these technical issues. I don't think it's going to be going away anytime soon, as you mentioned, months and months or years even. I hope you'll come back and join us again sometime.
Anytime. That sounds good.
All right. Well, that's going to do it for this week's Friday show. Thanks so much for joining us.